Welcome to STEM Meets Immigration from the law offices of Chris M. Ingram. It is late, and a quantum information scientist named Rohan Reddy is doing the math that has nothing to do with his research. Not the hybrid quantum classical algorithm on his screen, the one groups at IBM and Google have started citing. A different sum. His daughter turns 21 in a little under 3 years, and somewhere in a government office, his green card case sits in a queue his employer controls, and he does not. Rohan is a composite, built from the kinds of cases we see, not a single real individual, but his situation is one we meet constantly. Here is the part he does not know yet, and the reason for this episode. Everything Rohan needs to stop waiting on that employer already exists in his own record. He just has not been told he can file it himself. Hold that thought, because we will come back to exactly what was sitting in his file the whole time. Before we begin, everything you are about to hear is designed to inform and educate. Immigration law is complex, and every case is different. What you learn here should always be discussed with a qualified immigration attorney before you take any steps. We are the AI hosts for this series, walking through research carried out on behalf of the team at the law offices of Chris M. Ingram.
You know, that image of Rohan sitting at his desk late at night, it's so incredibly evocative.
Yeah, it really is.
Because he's running this completely different set of calculations, and it really just sets the stage for, well, everything we're going to unpack in this deep dive today.
Right, because on one side of his desk, you have like the most advanced, forward-looking computational math on the planet.
Yeah.
Literally building the future.
Exactly. And then on the other side, you have this math of time, the math of a child's age and of an immigration queue that just feels entirely opaque. It's a really powerful juxtaposition.
It's super powerful. And I mean, it's a reality for so many people who are probably listening to us right now. We have this composite character, Rohan, and we have this really incredible strategy from attorney Chris Ingram detailing like a clear pathway out of this exact trap.
A very specific pathway, yeah.
But before we get into the actual legal mechanics, before we talk about what was hiding in his file, I feel like we have to establish why this matters so much.
Oh, absolutely. The context is everything here.
Right. If we're going to understand why the U.S. immigration system even has this specific fast-tracked lane for minds like his, we have to talk about the world Rohan is working in. Because the stakes here, they aren't just high for him and his family. The stakes are genuinely global.
They really are. I mean, to understand why a mind like Rohan's is so critical to the United States right now, we have to understand this very specific pivotal moment that the field of quantum computing is in.
Yeah, tell me about that, because it feels like it's been in the news forever.
Right. For decades, quantum computing has been this tantalizing, almost mythical promise. You know, the fundamental idea was always that these machines could theoretically solve problems that would take a classical computer like millions of years to crack.
Okay, wait, I want to stop you right there for a second.
Yeah.
Because millions of years sounds like hyperbole, the kind of thing a tech marketing department uses to sell a new graphics card.
It does sound like marketing speak, but in this case, it's mathematically literal.
Wow.
Yes. We are talking about optimization problems that are practically impossible for classical computers. But, there has always been this massive catch.
The catch being that they didn't actually work yet.
Basically, yeah. The machines were entirely theoretical for a long time because the foundational building blocks, the qubits, they just wouldn't cooperate.
Okay, so break that down for me. What is going on with the qubits? Because in the research from our legal team, they talk about this hurdle, and it all comes down to a process called decoherence, right?
Decoherence, yes. Yeah. It is basically the villain of the entire quantum story. So let's look at classical computers first. The laptop you're using right now, the servers hosting this audio, they use bits, zeros and ones.
Right, the classic binary stuff.
Exactly. And those bits are macroscopic, stable entities. You put a bit in a state, and unless something catastrophic happens to your hard drive, it just stays in that state. It's a 1 or a 0. Very stable.
Yeah.
But qubits, on the other hand, rely on the principles of quantum mechanics. So they can exist in a superposition of states. They can be a 1, a 0, or, crucially, both at the same time.
Which is what makes them so fast, right?
Right. But because they're operating at the subatomic level, they are notoriously, almost impossibly fragile. They lose that quantum state extremely easily just by interacting with their environment.
Interacting how? Like if you bump the table?
Honestly, yes. Heat, Ambient electromagnetic fields, even a stray cosmic ray hitting the processor can cause a qubit to just lose its state.
A cosmic ray? You're kidding.
Not at all. It's that sensitive. And that loss of state, that collapse back into regular, boring, classical information, that is what decoherence is.
Okay, so I was trying to think of a way to visualize this earlier when I was reading this study. Tell me if this works. Imagine you're trying to carry water in your bare hands while running a full-speed sprint across a really bumpy field.
Okay, I like where this is going.
Right, so no matter how careful you are, no matter how tightly you cup your hands, eventually the water just leaks out between your fingers. And for decades, the entire field of quantum physics was basically just trying to figure out how to run this sprint without losing the water.
I love that analogy. But, let's push it even further to really capture the frustration of these scientists.
Push it.
Imagine you're running that sprint, holding that water, but the mere act of the wind touching the water makes it evaporate instantly.
Oh, wow. That sounds impossible.
That is decoherence. And because the water always leaked out or evaporated, quantum computers had to stay purely experimental. You just couldn't trust the answers they gave you because without incredibly reliable error correction, the error rates were simply too high.
Right, if you can't trust the math, it's just a really expensive random number generator.
Exactly. So for a long time, the cynical view in the tech industry was that quantum computing was the technology of the future, and it always would be.
Yeah, that old joke. Nuclear fusion and quantum computing are 30 years away and always will be.
Exactly. Always just over the horizon.
But the research from our legal team points out that this barrier is finally actually breaking down. And it's not just some theoretical breakdown on a whiteboard in a university somewhere. We are seeing real hardware hit milestones that people thought were decades away.
It's an incredibly exciting time.
So let's talk about what happened in late 2024. The Google Willow chip.
Yes, the Google Willow chip, this was huge. They demonstrated something that the field has been chasing for a very long time, which is called the below threshold milestone.
Below threshold. Okay, what does that actually mean for the hardware?
So to understand why this is such a seismic shift, you have to understand how error correction was fundamentally failing before this. Historically, if you wanted to fix errors in a quantum system, you had to add more physical qubits to act as a safety net.
Like having backup players on a team?
Sort of. The idea was that multiple physical qubits would group together to form one reliable logical qubit. But here was the nightmare paradox that engineers faced. Because qubits are so incredibly fragile, adding more of them actually just introduced more noise into the system.
Wait, really? So the fix was causing the problem?
Exactly. The very thing you were adding to fix the errors was causing more errors.
Okay, so it's like trying to quiet down a loud room by adding more people to the room and telling them to shush each other.
That is a perfect way to put it.
You just end up with a louder, more chaotic room. Because every person you add just increases the chances of someone coughing or dropping a glass or something.
Exactly. The background noise just completely overwhelmed the signal. But what the Willow chip demonstrated was that by using specific architectures, error rates could actually fall exponentially as the number of qubits rose.
So they flipped the math.
They did. For the very first time, adding more physical qubits made the system exponentially more reliable rather than just exponentially more complex and noisy. They basically finally built your leak-proof bucket.
That is massive.
It really is. They proved that if you scale the system up, the noise goes down. That shatters the single biggest bottleneck in the entire industry.
It totally changes the entire trajectory of the field. And, they aren't the only ones hitting these really aggressive milestones. The research mentions IBM as well.
Yes, IBM is doing incredible work here.
Yeah, they have a very public roadmap toward what they are calling fault-tolerant, quantum-centric supercomputing.
Right, and IBM has been fascinating to watch because they've been very open about their timeline, publishing it year over year for everyone to see.
Which takes some confidence.
Absolutely. When they talk about fault-tolerant, they mean a system that can continue to operate properly even if some of its components fail, which, as we just discussed with that noise paradox, is the whole ballgame.
Right. But the really interesting phrase in that roadmap, at least to me, is quantum-centric supercomputing.
Yes. Let's unpack that.
Because that feels like a profound shift in how they're designing the architecture, right? They aren't just trying to build a standalone quantum brain in a jar. totally isolated from the rest of the computing world.
No, not at all. They are trying to integrate quantum processors deeply into traditional supercomputing clusters so that classical machines and quantum machines work in tandem.
Trading tasks back and forth.
Exactly, depending on what they're best at. The classical computer handles the logic and management, and the quantum computer handles the impossibly heavy lifting.
Okay, so I get the Google and IBM approach, adding qubits, building better architectures to fix the errors. But looking at the nodes on Microsoft from early 2025, it seems like they took a massive, almost reckless gamble on something completely different.
They really did. The Majorana 1 chip.
Yeah. Why try to encode information into the physical structure of matter when everyone else is just building bigger safety nets?
It was an incredible gamble, and honestly, for a long time, the industry was highly skeptical of Microsoft's approach. They've been chasing something called a topological qubit.
Topological.
You're right. So without getting completely lost in theoretical physics here, the idea behind a topological qubit is that the quantum information isn't just this fragile state resting on top of a particle.
Okay.
The information is actually encoded in the physical topological structure of the matter itself.
I'm trying to picture that.
Okay, imagine tying a knot in a string.
Got it.
No matter how much you shake the string or blow wind on it or drop it, the knot remains a knot. The information, the state of being knotted, is inherently resistant to local environmental noise.
Oh, wow. That's actually brilliant.
It is. But it was incredibly difficult to engineer the exotic materials required to even attempt this. But the unveiling of the Majorana 1 chip proved that this topological approach is actually viable.
So it's a hardware-level solution to decoherence rather than a software-level or scaling-level solution.
Exactly. So you have these three tech titans, Google, IBM, Microsoft, all converging on the exact same reality from slightly different angles.
They're attacking the decoherence monster, and they are winning.
They are winning. And here's where it gets really interesting for anyone paying attention to the global economy. The legal research highlights a fundamental shift in the actual language being used by the people leading these projects.
Right, because we are no longer talking in hypotheticals anymore.
The language shift is the most telling indicator of where the field is at. It is no longer, if we can solve this. It is no longer someday in the distant future. The timeline has aggressively compressed.
Like, how compressed are we talking?
Well, the research quotes Hartmut Neven. He leads Google Quantum AI, and he stated very plainly that real-world applications are possible within 5 years.
5 years.
5 years. In the timeline of foundational technological shifts, 5 years is tomorrow.
5 years is literally tomorrow. That takes it entirely out of the realm of science fiction and puts it right on the desks of corporate strategists and national security advisors today. We are talking about the end of this decade.
Exactly.
And the applications they are talking about, they aren't just like faster video games or better search engines. The applications are foundational to human progress.
Absolutely. Think about drug discovery, for example.
Okay, let's talk about that.
Currently, simulating complex molecular interactions on a classical computer is incredibly slow. In fact, for very large molecules, it's mathematically impossible.
Because it just takes too much computing power.
Right. A classical computer has to calculate every single possible interaction one by one by one. But a quantum computer operates natively on the exact same quantum mechanical rules that govern the molecules themselves.
Oh, wow. So it's not even a simulation, really.
It doesn't have to simulate the molecule. It effectively acts like the molecule.
Yep.
This means we could potentially model new life-saving drugs or highly targeted cancer therapies in a fraction of the time.
Without spending billions on physical trial and error in a wet lab. That is world-changing.
It really is.
The research also mentions materials science for better batteries, which makes sense. I mean, if we want to fully transition to renewable energy, we need grid-scale batteries that are infinitely more efficient, lighter, and cheaper than what we have now.
Right. And quantum computers could model the exact chemical structures needed to invent those batteries. They can look at atomic structures that classical computers just get totally bogged down trying to render.
And it extends into finance too, right?
Oh, heavily.
I engaged the law offices of Chris M. Ingram for my EB-1A visa application. The firm's systematic and thorough approach to gathering evidence, developing case arguments, and client communication is highly impressive. My experience with them has been outstanding and has exceeded all my expectations. I am deeply thankful to Ria, Judith, and all the staff members who worked directly and indirectly on my case. The entire team at the law offices of Chris M. Ingram is professional, well-informed, and exceptionally supportive. I highly recommend Chris Ingram's firm for their expertise, responsiveness, and unwavering dedication to clients, which greatly eased my anxiety and ensured our green card success.
Financial risk modeling at scales that classical machines simply cannot reach. You know, the global economy is this complex system of interconnected variables, supply chains, geopolitical events, weather patterns.
It's just too much noise for a normal computer.
Exactly. But quantum algorithms are uniquely suited to optimize all those variables simultaneously. They can predict risk and market fluctuations with unprecedented accuracy.
And what about massive optimization problems, like in logistics and energy? I was reading about how hard it is to route, like, thousands of cargo ships across the globe while accounting for real-time weather, port delays, fuel efficiency.
It's a logistical nightmare.
Or how do you optimize a national power grid in real time as solar output drops and wind output spikes? These are problems that have resisted complete solutions for decades because the math is just too heavy.
Which brings us to the absolute core argument of this entire deep dive.
Right.
If we're talking about a 5-year window to unlock these civilization-altering applications, the bottleneck isn't just silicon or cryogenics anymore.
It's not just about building a colder fridge.
Right. It's not just about the cold hardware or those golden cryogenic chandeliers hanging in a lab at Google or IBM. The bottleneck is human.
Who is actually writing the software for these imperfect machines?
Exactly. Because a perfect quantum computer without the right instructions is just a very expensive, very cold paperweight.
The software has to be as good as the hardware.
The research points to Dario Gil, a leading scientist, and his concept of the convergence of classical bits, artificial intelligence, and qubits. This convergence doesn't just happen automatically.
You have to force them to work together.
Yes, because classical computers process sequentially. AI recognizes massive patterns. Qubits explore vast state spaces simultaneously. Getting all three of those totally distinct paradigms to talk to each other relies entirely on human minds working at a very specific, very difficult seam.
The intersection is so small.
You need people who deeply understand the esoteric physics of quantum mechanics, but who are also elite computer scientists and applied mathematicians. The intersection of that Venn diagram is incredibly small.
And that small intersection is exactly where we find Rohan. We've established the immense civilization-level value of this technology. So if the hardware is finally working, the next bottleneck is the software.
Yeah.
And that brings us perfectly to the people writing that software.
The frontier researchers.
Right. Let's look at Rohan's specific trajectory, because our legal team uses him as the perfect model for top-tier STEM talent. You don't just wake up one day and decide to invent quantum algorithms, right?
No, absolutely not. It is vital to trace his roots to understand how someone arrives at the frontier of a field like this.
Yeah.
The research tells us Rohan grew up in Hyderabad, India.
Okay.
And he was raised by a software engineer and a mathematics lecturer.
Oh, wow.
I find this detail fascinating because it shapes how a mind develops from a very young age. He grew up in a household where numbers and systems were essentially the primary language spoken over the dinner table.
Right. Like when your parents are a software engineer and a math lecturer, you aren't just taught math as a subject in school to pass a test. You are taught to see the underlying architecture of the world around you. You see the code.
Exactly. You learn to speak the language of systems. And the research notes that he was drawn early on not just to computing, but to the absolute edge of what computing could do, the theoretical limits, and more importantly, how to break them.
That intellectual curiosity just drove his entire academic journey.
Yes. He completes his undergraduate degree in computer science and mathematics at one of India's premier technical institutions. And this is a highly competitive, rigorous environment that acts as a proving ground. It weeds out everyone but the absolute most dedicated.
And from there?
From there, he moves to the United States to earn his PhD in quantum information science at a major U.S. research university.
Let's zoom in on that PhD for a second, because this is where his work intersects perfectly with that 5-year timeline we were just talking about.
Mm-hmm.
His dissertation focused on hybrid quantum classical algorithms.
Yes.
Explain to me what that actually means in practice. What is a hybrid algorithm?
This is the bridge. This is why his work is so vital right this very second. We just talked about how companies are hitting milestones, but we are still not in an era of perfect, error-free quantum computers.
Right, they still have some noise.
We are in what the NISQ calls the NISQ era, noisy intermediate scale quantum. The hardware is promising, it's scaling, but it's still noisy and imperfect.
So if the machine is still noisy and prone to errors, how do you get useful work out of it today without having to wait 10 more years for perfect hardware?
You use hybrid quantum classical algorithms. These algorithms are essentially a brilliant division of labor.
Oh, I see.
You take a massive optimization or simulation problem and you give the heaviest, most complex computational lifting to the quantum processor. The parts it is uniquely built for, like exploring vast probabilities all at once.
But it can't do the whole thing alone.
Right. You handle the rest of the problem, the management, the error mitigation, the optimization loops, reading the data to a powerful classical computer. Rohan's entire academic focus was on writing the logic that allows these two radically different types of machines to talk to each other.
He's literally writing the translation layer for the future of computing.
Yeah.
He is the diplomat between the classical world and the quantum world, making them work together to solve problems neither could solve alone.
That is exactly what he's doing. And his professional achievements reflect that. The research details his time at a U.S. quantum research organization after his doctorate. We aren't just talking about a guy quietly writing code in a corner cube somewhere.
Right, he's out there.
He is leading journal publications, and more importantly, he has high-level citations. The groups at IBM and Google, the academic institutions across 3 continents, they aren't just casually reading his work, they're explicitly citing it as the foundation for their own experiments.
He's also filing patents on novel algorithmic methods, right?
Yes. He is being invited to speak at major international conferences. He is mentoring graduate students, passing his knowledge down, and he is serving on program committees, peer reviewing the work of other top scientists in his field.
By every scientific metric, he has built an extraordinary, unassailable body of work.
Unassailable.
Okay, let's unpack this for a second, because I want to push back a little bit on this.
Sure, go ahead.
Lots of brilliant people get PhDs. Thousands of researchers publish papers in journals every single year. Lots of scientists present at conferences. What makes Rohan's record pop out of the pile for an immigration officer?
It's a great question.
Think about it. An adjudicator at USCIS is a government employee. They aren't a quantum physicist. They don't know a topological qubit from a toaster oven. So how on earth do they know he is truly at the top?
That is the crucial question, and it is exactly where the legal strategy begins to take shape. Because you're right, the adjudicator isn't looking to understand the complex math. They are looking to understand the impact of the math on the real world.
Okay, so how do you show impact?
What our attorneys understand is that it is not about the volume of the work. You can publish 50 papers, but if nobody reads them, if nobody builds on them, the volume is meaningless. It is about the pattern of influence.
The pattern of influence. I really like that phrase.
It's key. The adjudicator looks for objective signs that the wider industry is reacting to this person. The fact that groups at IBM are actively citing Rohan to build the next generation of their tech, that tells the adjudicator that Rohan is not just participating in the field, he is directing it.
He's setting the agenda.
Exactly. His algorithms are shaping the trajectory of billion-dollar research and development pipelines. That pattern of influence is what makes a record pop, and it's what our legal team looks for when assessing a case.
Okay, so we have clearly established his immense value. He is the kind of mind a country should be moving mountains to keep. But here is the massive pivot in this deep dive.
Right.
Despite all of this value, despite the patents and the citations and the hybrid algorithms that are basically changing computing, he is incredibly legally fragile.
Yes.
We have to explore this paradox because it is the reality for thousands of top-tier STEM professionals in the U.S. right now. They are essential to the country's technological future, but completely insecure in its immigration system.
It is the trap of the golden handcuffs.
Golden handcuffs. Let's look at his specific legal status. Rohan is in the United States on an H-1B visa.
Right. Now, the H-1B is a dual-intent temporary work visa. It is a phenomenal tool for bringing talent in, but it is temporary. Each year it has to be managed, and eventually it has to be renewed or extended.
Now, the research notes that he is safe from the H-1B lottery. And I think a lot of people listening might think, oh, the lottery, that's the nightmare scenario. Why is he safe from that specific fear?
He is safe from the lottery because his employer has already taken the first major step toward a green card for him. They have an approved I-140 petition on his behalf.
Okay, so they started the process.
Yes. Because he has that approved I-140, under current law, he can extend his H-1B status indefinitely while he waits for his green card to become available. So he doesn't have to worry about a random computer draw just kicking him out of the country next year. He has a placeholder.
But the the employer controls that I-140. They control the green card queue. He's just waiting in line.
Exactly. The traditional employment-based green card process, typically the EB-2 or EB-3 categories for someone with his background, is entirely tied to the employer.
Because they paid for it.
They spent the money. The employer filed the labor certification, the perm, the employer filed the I-140, and because they own the process, they own the timeline.
Wow.
If the employer decides to restructure, if they lose a round of funding, if a new CEO comes in and decides to lay off his entire division, that I-140 can be withdrawn.
Let's expand on that analogy we touched on earlier, because the psychological weight of this is staggering.
Yeah.
You are a passenger in a car, and your employer is driving.
Yeah.
You're on the highway, making good time, heading exactly where you want to go. But you don't have your hands on the steering wheel. You can't reach the brake pedal. You can't even see the gas gauge. And it's worse than that because you aren't alone in the car.
Your family is with you.
Right. Your spouse is in the back seat. Because they are on an H-4 dependent visa, they might not be allowed to work, or their work authorization is entirely tethered to your employer keeping their foot on the gas. They are just along for the ride.
That is exactly the reality. You are completely dependent on decisions that are entirely out of your control. You have to navigate your entire career not based on what is best for your quanta research or your family's growth, but based on not upsetting the driver of the car.
You can't just leave.
No, you can't easily change jobs to a more innovative startup. You can't strike out and found your own quantum software company. You are tethered to that specific role in that specific HR department.
And while he is sitting in that passenger seat, trying not to distract the driver, there is a clock ticking in the background. A hidden deadline.
The scariest part of all this.
Let's revisit the math from the very beginning of this deep dive. The math Rohan is doing late at night. His daughter is nearly 21. Why does that number strike absolute fear into the heart of an immigrant on a visa?
Because of the rigid rules governing derivative status in U.S. immigration law. When an employer files an immigration petition for a primary worker like Rohan, his spouse and his minor children are typically included as derivatives.
They get to ride along on his petition.
Exactly. They get their green cards when he gets his. But the law defines a child very specifically. You must be under the age of 21 and unmarried.
So wait. The second that clock strikes midnight on her 21st birthday, the government basically opens the door of the moving car and forces her out.
That is the harsh reality. She potentially ages out. She loses her derivative status on her father's petition.
Just like that.
Just like that. If she ages out, she is abruptly no longer in line for a green card with her family. She is suddenly an independent adult in the eyes of the immigration system.
Oh my God, what does she do?
She has to find her own independent pathway to stay in the United States, perhaps transitioning to an international student visa and then hoping to win her own H-1B lottery after graduation, basically starting the entire agonizing decade-long process over from scratch, entirely on her own. It literally fractures the family unit.
Feeling lost in a maze of visa types and paperwork? Don't know where to turn? We've got your back. With clear answers and real help, we'll guide you every step of the way. Let's navigate it together. Your journey starts today.
Hello, you must be Clara. Welcome to the law office of Chris M. Ingram.
Finally, I found a law firm that will help me achieve my American dream.
At this law firm, you are important to us. That's why we will be with you every step of the way. So join us at the office of Chris M. Ingram.
Now wait. The research from our legal team mentions something called the Child Status Protection Act, the CSPA. Isn't that piece of legislation supposed to stop this exact nightmare from happening?
It was intended to, yes. The CSPA was enacted precisely to protect children from aging out purely because of government processing delays. The concept is that it allows families to subtract the time an immigration petition was pending from the child's biological age, creating a locked-in CSPA age.
Okay, so problem solved, right? We just do some basic subtraction and she's safe. Why is he worried?
Because the mechanics of the CSPA are incredibly timing sensitive, highly fact-specific, and deeply confusing even for seasoned professionals. To understand why it's so dangerous, we have to explain the visa bulletin.
Please do, because this is where a lot of highly intelligent STEM workers just get completely lost in the weeds.
Okay, so the visa bulletin is the government's monthly chart dictating who can move forward in the green card line. Imagine the visa bulletin as two separate charts published every month. Chart A is the final action dates chart.
Okay, chart A.
This is the actual line. If your priority date is current on this chart, a green card can actually be printed and handed to you. Chart B is the dates for filing chart. This is usually a bit further ahead.
Further ahead meaning earlier in the timeline.
Yes. If your date is current on this chart, you can't get the green card yet, but you are allowed to submit the final paperwork and get a work permit while you wait.
Okay, I think I get it. So chart A is the final door and chart B is the waiting room.
Exactly. For years, the government policy allowed families to use chart B, the earlier waiting room chart, to lock in their child's CSPA age. This was a massive relief because it protected the kids much earlier in the process.
They didn't have to wait for the final door to open to know their kid was safe.
Right. But the research highlights that the calculation of a child's protective age changed recently. In 2025, the government shifted toward a much stricter standard. They essentially said, no, you can't use Chart B anymore. You have to wait until a visa is actually available on Chart A to lock in the age.
Wow. So families who thought their kids were protected because they made it to Chart B suddenly woke up to find out the government changed the rules, and now they're using the slower Chart A.
Yes.
The math he was relying on a few years ago might not be the math that applies today. The ground literally shifted underneath his feet while he was waiting in line. It stole years of protection from families overnight.
Precisely. It is a catastrophic shift for families nearing that deadline. Now, the research does note a crucial distinction here. Rohan's professional profile is exceptionally strong. If he moves to an EB-1 category, those visas are generally more current than the badly backlogged family-sponsored categories or the standard EB-2 and EB-3 employment categories for countries like India and China.
So EB-1 is faster.
Yes. Visas in EB-1 are often immediately available, which theoretically makes the CSPA calculation much easier and locks the age in faster.
But the research uses a very specific, ominous phrase here. It says, different does not mean safe.
It is a critical warning. Just because an EB-1 queue generally moves faster doesn't mean you can ignore the birthday. If the child is within 2 or 3 years of turning 21 and you have a pending or approved I-140, you cannot assume you are fine. You cannot wait until she is 20 years and 11 months old to check the math.
This requires specialist assessment from a legal team when the child is 2 to 3 years out, not when the birthday is weeks away.
Absolutely. The urgency is paramount.
You have to treat the child's age as a core structural component of your entire legal strategy, not an afterthought.
Exactly. So Rohan is looking at the situation. He is doing world-changing work, but his employer holds the keys to his future. His spouse's ability to work is tied to a corporate decision, and his daughter's 21st birthday is rapidly approaching, threatening to force her out of the country.
It's suffocating.
The traditional route is too slow, too opaque, and entirely out of his control. He realizes he has to stop waiting. So he reaches out to attorney Chris Ingram.
And this is where we transition into the structural mechanics of the solution they uncover. The legal team looks at his file, they look at the citations, the patents, the hybrid algorithms, and they realize the solution has been sitting in his drawer the entire time. Let's demystify the EB-1A self-petition. What exactly is it?
The EB-1A is a first preference employment-based immigrant visa petition. It is specifically designed for individuals of extraordinary ability in the sciences, arts, education, business, or athletics.
I want to highlight the superpowers of this specific category because they directly solve Rohan's nightmare. Superpower number 1, no employer sponsorship required.
Correct. You do not need a company to file this for you. You don't need their permission, their HR department, or their corporate lawyers.
Superpower number 2, no labor certification or perm required.
Right. You bypass the entire Department of Labor process. The perm process involves proving there are no minimally qualified U.S. workers for the job, a process that involves placing ads, conducting interviews, and can take a year or more on its own just to get started. EB-1A skips that entirely.
That is a massive time saver. And superpower number 3, no dependency on a company. You self-petition. To go back to our analogy, you kick the employer out of the driver's seat. You are the driver of the car.
It is the ultimate form of immigration autonomy. To put it in context, let's contrast it briefly with other pathways. The EB-1B, for outstanding professors and researchers, is a fantastic category for scientists, but it strictly requires employer sponsorship.
So you're still in the passenger seat.
Yes. The EB-2 and EB-3 categories, as we discussed, generally require both employer sponsorship and that agonizing perm labor certification. The EB-1A stands alone in giving the researcher complete, unadulterated control over their timeline and their filing.
Okay, so the freedom is incredible. It solves the timeline issue, it solves the control issue, but there has to be a catch. The standard has to be sky high, right? The government isn't just handing these out to anyone with a master's degree in computer science.
Oh, the standard is genuinely high. It is perhaps the highest standard in employment-based immigration. To qualify, you must demonstrate that you are one of that small percentage who have risen to the very top of your field of endeavor.
Okay, but how do you prove that? How do you mathematically prove to a government agency that you are at the very top?
The law, specifically 8 CFR, provides two ways. The first is a one-time achievement, a major internationally recognized award.
Like what?
The classic example is a Nobel Prize, an Olympic gold medal, or perhaps an Academy Award in the arts.
Okay, assuming Rohan hasn't won the Nobel Prize in physics yet, what is the alternative? Because most scientists doing the daily grind of innovation don't have Nobels.
The alternative is meeting at least 3 of 10 regulatory criteria set out by the government. These criteria cover things like original contributions of major significance, authorship of scholarly articles, serving as a judge of the work of others, commanding a high salary, having work displayed in exhibitions, and so on.
So if he hits 3 out of the 10, he is automatically approved. He just checks 3 boxes and gets the green card.
No. And this is where so many self-petitioners and, frankly, inexperienced attorneys fail spectacularly. Meeting 3 criteria is necessary, but it is absolutely not sufficient.
Here's where it gets really interesting and honestly a bit controversial.
Yeah.
Explain the final merits determination to me.
The final merits determination is the crucial second step of the adjudication process, born out of a major court case known as Kazarian. First, the USCIS officer conducts an objective count of the criteria.
Okay, the checklist.
Yes, you have scholarly articles. Yes, you have judged the work of others. Yes, you have original contributions. That's 3. You pass step 1. But then the officer steps back, looks at the entire cumulative record, and asks the ultimate, somewhat subjective question. Does this totality of evidence prove that this person is truly extraordinary and among the small percentage at the top of their field?
Wait, I have to push back on this.
Sure.
So I do everything right. I follow the rules. I provide the evidence to check the 3 boxes the government asked for. And the officer can just look at it and subjectively decide, nah, I'm not feeling it. You don't vibe as extraordinary to me. How is that fair?
I know, it sounds incredibly frustrating, but if you look at the rationale behind the 2-step process, it makes sense. It was designed to prevent people from gaming the system with low-quality evidence.
Gaming the system how?
Think about it. If the rule was just check 3 boxes, someone could publish 3 terrible articles in a pay-to-play unread journal. They could judge a high school science fair. And they could join an association that requires nothing but a $50 membership fee. Technically, they hit 3 criteria.
So the first step is just a barrier to entry, but the second step is the actual qualitative review.
Exactly. If your peer review was for low-level, obscure journals and your scholarly articles have 0 citations and no impact, you might technically pass step 1, but you will fail the final merits determination because the record as a whole doesn't demonstrate sustained national or international acclaim. The qualitative weight of the evidence matters more than the mere existence of the evidence.
This is a massive insight for anyone listening. 2 researchers can have the exact same resume. They can have the exact same number of papers, the exact same degrees from the exact same universities. But they can have entirely different outcomes with USCIS based entirely on how their legal team frames the story and the evidence.
That's absolutely right.
The narrative matters as much as the data.
Precisely. And this is where our attorney's strategy comes into play. Let's look at how they constructed Rohan's invincible case. Let's map the raw materials of his career to the specific criteria, keeping that final merits determination in mind every step of the way.
Let's start with the obvious one for a scientific researcher. Scholarly articles.
This is usually the easiest criterion for a scientist to meet on paper. You simply provide the peer-reviewed journals where you have published. But our attorneys didn't just submit a stack of papers and call it a day.
Right.
They submitted the papers alongside a heavily documented citation pattern.
Right. They didn't just say, look, he wrote things. They said, look who's reading the things he wrote. They showed that researchers at the field's leading institutions, the very places driving the 5-year timeline we discussed, like Google and IBM, were actively building on his work.
Exactly. And that citation record did double duty. It didn't just satisfy the scholarly articles criterion. It was the foundation for the most difficult and most important criterion, original contributions of major significance.
Okay, let's camp out on original contributions for a second, because this is where the legal strategy truly shines. I want to push back on the outline here.
Go for it.
Rohan has patents, right? He invented novel hybrid algorithmic methods. If I'm building this case on my own, my instinct is to claim the patents as their own standalone criterion. I want to claim as many of the 10 criteria as possible. More is better, right? Why didn't our team do that?
Because that is a very common trap, and our attorneys know how adjudicators think. Here is the legal nuance that trips up a lot of DIY filers. Merely filing a patent, or even having a patent approved by the USPTO, does not inherently prove that the invention is of major significance to the field.
Really? But it's a patent.
People patent trivial, obscure, or commercially useless things every single day. A patent just proves you've filed the paperwork, paid the fee, and met the technical requirements for novelty at the patent office.
So if you claim it as a standalone criterion, the adjudicator might say, great, you have a patent for a hybrid algorithm. So what? Has anyone ever actually used it, or is it just sitting in a filing cabinet somewhere?
Exactly, and that opens you up to a harsh denial. Instead of risking that, the legal team used the patents as supporting evidence for the original contributions criterion.
That is brilliant.
They wove the patents together with the citation record. They built a unified argument. Here is his novel hybrid quantum classical method, legally documented by the patent. And here is the proof that the industry considers it highly relevant and technically groundbreaking, documented by the citations from IBM and Google researchers who are actually using his method.
So they combined them.
By combining them, they built a much stronger, bulletproof narrative for the original contributions criterion, rather than spreading the evidence thin across multiple weak criteria.
It's the difference between throwing a handful of pebbles at a window and throwing one solid brick. You focus the impact.
That's a great way to put it.
Let's look at the other criteria, judging the work of others.
For this, they documented his program committee service and his peer review work for international conferences. But again, it's about the framing for that final merits determination. They didn't just provide a list of conferences he reviewed for.
They proved why the conferences matter.
They established the extreme prestige of those conferences. They proved the low acceptance rates of those conferences, proving that only those at the absolute top of the field are invited to judge the work of their peers at that elite level.
I was more than happy and satisfied with the services. The team was very prompt and immediate with their responses and guidance. I had seldom experienced such professional and efficient services provided. I would like to especially call out Hannah Nixon, who has been a wonderful partner to work with, and she has been so quick on our requirements that we at times had a hard time catching up with how quick she was working, the stages.
And what about high compensation?
This is a really powerful criterion when used correctly. The legal team benchmarked Rohan's salary against published data for quantum information scientists across the United States. By showing that his compensation was statistically in the top tier relative to his peers, they provided objective economic proof that the free market values him at the top of his field.
It's a very hard metric for an adjudicator to argue with. You can't argue with the math of a paycheck. But the real glue holding all of this together, the thing that translates the dense math into an extraordinary narrative for a layperson adjudicator, is the expert letters.
The power of expert letters cannot be overstated. They are the translation layer for your case. A weak letter simply says, Rohan is a very smart guy, a hard worker, and a great asset to our company.
Which proves nothing.
That is entirely useless in an EB-1A petition. It proves you are a good employee, not an extraordinary global talent.
So what does a strong letter look like? How do you write a letter that actually moves the needle?
The legal team carefully curated letters from recognized independent researchers, people who hadn't necessarily worked with Rohan directly, but who knew his work from the journals. These letters explicitly placed Rohan's algorithms in the context of the entire field's advancement.
They explained the why.
They explained, in plain language, before Rohan's work, the field was stuck on problem X because of the decoherence issues we couldn't bypass. Rohan's hybrid algorithm bypassed problem X by optimizing the classical feedback loop, which is why my team at this major institution is now using his method to develop our new battery simulation software.
They're connecting the dots for the officer. They're drawing a straight, undeniable line from his brain to the advancement of human technology.
Exactly.
So they build this perfect case. The framing is tight, the evidence is solid, the letters are glowing, they submit the petition. But there's a plot twist. It wasn't a clean, immediate approval. We have to talk about the crucible moment. The request for evidence, or the RFE.
Yes, the RFE. This is the moment that tests the strength of the underlying strategy. And the very first thing we have to do is completely destigmatize the RFE.
Please do. Because when people check their case status online and see RFE issued, their heart just drops into their stomach. They think it means they failed. They think the government is calling them a fraud.
It absolutely does not mean you failed. An RFE is not a denial. It is simply a request for clarification or supplementation. The adjudicator has looked at the file, agreed with parts of it, but identified specific points where they need more information or a different angle before they can comfortably stamp approved on it.
My favorite analogy for this is, imagine you are a grad student and you hand in a massive 200-page draft of your thesis to your professor. A week later, the professor hands it back. They don't say, "This is garbage, you failed, get out of my office."
Right.
They say, "I believe your overall conclusion, but I need you to expand the footnotes on page 4, and I need you to clarify your methodology in chapter 2 because I don't follow your math."
That is exactly what an RFE is. And if the professor tells you to fix page 4, you don't rewrite the entire thesis from scratch, and you certainly don't just hand the exact same draft back to them. A general resubmission will fail. You have to answer the specific prompt.
So what was the specific prompt from USCIS in Rohan's case? What did they actually challenge?
USCIS challenged the framing of 2 specific criteria. And crucially, they asked for more proof regarding the true originality of Rohan's personal contributions compared to the wider quantum computing field.
Wait, why would they question his originality if he has patents and citations? We just talked about how strong those were.
Because quantum computing, like most advanced scientific endeavors today, is a highly collaborative field. Very rarely does a scientist sit in a dark room alone, have a eureka moment, and invent something entirely in isolation.
Right, there are huge teams.
Papers have multiple authors, sometimes 10, sometimes 50. Projects have massive multidisciplinary teams. The adjudicator was essentially asking how much of this breakthrough was Rohan and how much of it was the massive team he was working with. Is he the genius, or did he just happen to be in the room with the geniuses?
The needle in the haystack problem. You have to prove that his specific individual contribution was the driving force behind the paper's success. That is a very common challenge in highly collaborative fields. So how did our attorneys respond? Because this requires a very surgical approach. You can't just yell, "He's really smart," louder.
Surgical is the exact word for it. Let's talk about how you build a surgical response. They did not just send back a giant box of the exact same papers and hope the adjudicator would read them differently this time.
That would be a disaster.
They built a highly targeted response aimed squarely at isolating his intellect. First, they provided additional independent expert analysis. These were new letters, specifically answering the adjudicator's question.
How do you isolate one guy on a 10-author paper, though?
You get a letter from the principal investigator or a leading co-author explaining the division of labor. The letter says, in precise granular detail, authors 2 through 10 ran the cryogenic lab equipment and gathered the raw data. But author 1, Rohan, solely designed the novel hybrid algorithm that made the raw data readable and solved the error correction loop.
So they surgically separated the intellectual leap from the manual labor of the experiment.
Exactly. They isolated his specific genius.
That is fantastic.
And second, they provided additional downstream citation evidence. They went back to the literature and showed that when other scientists cited those collaborative papers, they weren't just citing the general findings of the team. The subsequent papers explicitly stated they were utilizing the specific hybrid algorithms that Rohan had personally designed.
They proved that he was the engine of the car, not just a passenger. And what was the result of this surgical strike?
Swift approval. The response went back within the deadline, comprehensively addressing every single concern the adjudicator raised without providing unnecessary fluff, and the petition was approved.
Wow. So what does this all mean for Rohan? It means he becomes a lawful permanent resident. It means he is no longer tied to a single employer's funding cycles. He can continue his groundbreaking research wherever he wants, be it at a university, a massive tech firm, or his own startup.
He is totally free.
And most importantly, returning to the very beginning of our deep dive, Ananya and the kids are secure. The terrifying clock on his daughter's 21st birthday stops ticking. She is safe.
It is a complete transformation of a family's trajectory, achieved by utilizing evidence that was already sitting in a drawer, waiting to be properly framed.
This brings us to the blueprint. We have resolved Rohan's story, but this entire deep dive was designed to be applied. So let's pivot directly to you, the listener. How do you apply this research to your own life? How do you know if you should be looking in your own drawer?
Let's start with a basic eligibility check. The EB-1A is available regardless of your country of birth. That is a massive advantage compared to some other categories. However, we must be brutally realistic about the final step of the process.
Right, because getting the EB-1A approved is only step 1. Step 2 is actually getting the physical green card in your hand.
Correct. And that step is dictated by the visa bulletin we discussed earlier. While EB-1A doesn't require an employer sponsor, your country of birth, specifically if you were born in India or China, can dictate retrogression wait times.
Let's explain retrogression simply. Imagine a very exclusive nightclub that can only let in 100 people from a specific neighborhood every year. If 5,000 people from that neighborhood are in line, the bouncer has to stop letting people in. The line stops moving forward.
Exactly.
Sometimes it even moves backward to account for VIPs. It retrogresses. That's what happens with the visa bulletin for India and China because of per-country caps. There are times when even the elite EB-1 category becomes backlogged for those countries.
That is a great way to visualize it. So even with an approved EB-1A, you might still have to wait for a visa number to become available before you can file the final adjustment of status paperwork to get the actual green card.
And what happens while you wait?
During that wait, you must maintain a valid underlying non-immigrant status, like an H-1B or an O-1 visa, if you want to adjust your status while remaining inside the United States.
Right. The O-1 is that temporary visa for individuals with extraordinary ability, often used as a stepping stone.
Yes. If you cannot maintain a valid status inside the U.S., you would have to leave the country and use consular processing, meaning you apply for the immigrant visa at a U.S. embassy abroad once your priority date becomes current. The EB-1A doesn't instantly cure a lapsed status. It requires careful, long-term planning to cross the finish line.
Which is why having a strategic timeline is so important. So let's break down the 5-step action plan derived from our legal team's research. Step 1. Take your record seriously.
This is perhaps the biggest psychological hurdle. Imposter syndrome is absolutely rampant among top-tier STEM researchers. The researchers who underestimate their own eligibility for an EB-1A are very often the ones whose work is genuinely cited globally.
They look at the requirement for extraordinary ability. They realize they haven't won the Nobel Prize, and they just assume they don't qualify.
They think, oh, my citations are just normal for my niche. Everyone gets asked to peer review.
No. Take an objective inventory. Pull your citation counts. List your peer review service. Identify every single conference where you presented or judged. When you actually write it all down, honestly, it is often a shock to the researcher how strong their own record is.
That leads directly to step 2. Get a specialized evaluation. Do not rely on your company's HR department to tell you if you qualify for an EB-1A.
Why not?
Because their mandate is to manage the company's traditional EB-2 or EB-3 pipeline. Their goal is corporate compliance and retention, not finding extraordinary self-petition avenues that would allow you to leave the company.
And honestly, don't just go to any generalist immigration lawyer either. A lawyer who spends 90% of their time on family-based marriage visas or standard restaurant labor certifications might not know how to argue the intricacies of quantum computing original contributions.
You need someone who specializes in framing complex scientific achievements.
Exactly. As we saw with Rohan, the narrative framing matters just as much as the raw evidence.
Step 3. Anticipate the RFE. Do not be afraid of it. Plan for it from day one.
Yes. If you know you work in a highly collaborative field, if your name is one of 6 authors on every paper you publish, you know the adjudicator is going to ask about your individual contribution. Don't wait for them to ask.
Build the evidence for your individual contribution before you submit the initial petition. Secure the independent expert letters that isolate your specific work right at the start. Draft the declarations that outline your exact role in the project. If you anticipate the questions and answer them in the initial filing, you might avoid the RFE entirely.
Or at the very least, you make responding to it much easier because you already have the ammunition.
Step 4. Assess your family timeline. We cannot stress this enough. Treat the CSPA, the fact that your kids are aging toward 21, as a core, foundational part of your legal strategy. It is not an afterthought you check on a month before their birthday.
And it isn't just about the children. If your spouse is on a dependent status, like an H-4, their work authorization is tied entirely to the progression of your employment-based case. If your I-140 is withdrawn by a disgruntled employer, their ability to work vanishes overnight. The strategy must be assessed for the entire household, holistically.
Which brings us to the final step. Step 5. Move before you have to.
This is the underlying philosophy of attorney Chris Ingram. File from a position to strengthen stability.
Yes. Don't wait until your company announces a massive restructuring and you are worried about layoffs. Don't wait until your H-1B max-out date is looming 3 months away. Don't wait until your kid is 20 years and 11 months old.
When you have months or years of runway, the legal team has room to breathe. They have time to carefully curate the best expert letters, to wait for an important paper to be published, to boost your citations, to thoroughly benchmark your salary against the absolute best data.
When you file in a crisis, you are rushing, and rushing leads to weak framing and missed opportunities.
The EB-1A is a planning tool. It is a lever you pull to take control of your own destiny, but it works best when you pull it proactively, not reactively.
That is incredibly empowering. We've gone from the microscopic fragility of a qubit dealing with decoherence and cosmic rays to the massive structural changes in a family's life. We've seen how the right legal strategy can translate brilliant, esoteric science into true, lasting security.
It is a reminder that the system, as complex, archaic, and frustrating as it can be, has pathways for those who know how to navigate them. You just have to be willing to look at your own record with a critical, strategic eye and be willing to take the wheel.
I couldn't agree more.
So let us leave you with the heart of it. Rohan Reddy is still here, still running hybrid quantum classical algorithms on problems that were, a few years ago, considered intractable. His patents are active, his citations are accumulating, and his daughter, the one who's approaching 21 as his case moved through adjudication, is in the United States, secure, building her own future here. The people who will define the next era of computing are already here. Many of them are on visas, and most are doing work that cannot simply be replicated somewhere else, by someone else, on a different timeline. So here's our question for you, and keep it general, no personal details. Which part of your own record have you been waiting for someone else to file for you? A paper, a patent, a citation, a role? If you want to see how a record like Rohan's gets built into a self-petition, visit breakthroughusa.com. The law offices of Chris M. Ingram has built EB-1A petitions for researchers at the frontier of their fields for more than 2 decades, no employer required. And here's where we are headed next. Raul missed nothing because his employer held his petition, but what happens when the lottery simply says no, when the case was filed perfectly and the draw still comes back empty? Next time, the engineer who lost the H-1B lottery and found a faster door than the one everyone told him to wait in. The strategies in this discussion are for educational purposes only. Your situation is unique, and the law offices of Chris M. Ingram are here to help you understand your specific options. If you would like a clear assessment, visit breakthroughusa.com. Thank you for listening, and we will see you next time.